Thank you, Mr. Chairman. I again present the committee Senate Bill 692. When SB 692 was originally heard in committee, the bill simply gave all engineering disciplines the same status. This language did not affect the opposition, but the committee approved it nonetheless. To ensure that the committee's consideration given and my effort as author of the bill would be effective, I requested the opinion from the Legislative Council, which all of you have by now read. The opinion concluded that the Professional Engineers Act gives licensed civil engineers a complete monopoly over any professional services to develop fixed works. The exemptions are few and minor, do not recognize the necessary contributions from other engineering disciplines and professions. SB 692, as it was approved by committee, would have been ineffective as a result. SB 692, as it is now amended, will provide California with a PE Act that is consistent with the rest of the nation, as well as bringing it in line with the current practice. Now the law can no longer be ignored. Our state, and more importantly our citizens, must be protected by allowing the use of all competent expertise to address the complex issues that our society faces, especially with new high-tech and green tech engineering solutions that are required to meet the needs of California today. And I have several people with me to testify.
Okay. Witnesses in support, please. Identify yourself.
Andrea Fox from the California Farm Bureau. Glad to be back again. See you all again. The Farm Bureau sponsored SB 692 because of the ever-increasing regulations and requirements that have been placed upon the agricultural community to meet the needs, to provide what is needed in producing the abundant food that we produce, and also to protect the environment. Too often the arbitrary requirement that a civil engineer must be involved, even if not necessary, has caused increased costs and delays. The Farm Bureau appreciates Ms. Walters' open access to the vital expertise needed by agriculture. She has been most helpful in requesting a legal opinion from the Legislative Council to help us better understand the law, to see how it needs to be reformed. The opinion makes it clear the licensed civil engineers have a monopoly when we develop fixed works for agriculture. The law is even more restrictive than we realized before now. If biologists, chemists, agricultural engineers, and other experts are used in food processing, irrigation, and waste discharges, just a few examples, we now know that they must be licensed as civil engineers, and they also must be competent. They cannot just sign on the work of others. If SB 692 will allow our industry to have access to the expertise we need to protect the public. It is difficult, if not impossible, to see how we can meet the public's expectations unless the law is reformed. Thank you.
Thank you. Any other witnesses?
Good afternoon. My name is Enrique Lavernia, and I currently have the privilege of serving as the Dean of Engineering at UC Davis, and I'm here representing 7 engineering deans from the UC system, as well as a number of other Cal State deans and some private school deans who support SB 692. And we support 692 for 3 reasons. First, because it recognizes the value and importance of all engineering disciplines and makes competence the standard under which services are delivered, a practice which I might note is consistent with that in other states. Number 2, 692 will ensure that the people in this state will benefit from the depth and breadth of the engineering expertise in this state. And number 3, at a time when we are struggling in academia to graduate more and more engineers, failure of passage of 692 will introduce unnecessary questions as to the future of current and future engineering students in this state. Thank you.
Thank you. Other witnesses?
Good afternoon, Mr. Chair and members of the committee. Deborah Matos for the Independent Oil Marketers Association. We have been supportive of this bill since last year. We're also supportive in its amended form. We're very pleased to see the new Leg Council opinion. We represent small businesses in the state. We hire chemical engineers, environmental engineers, all sorts of engineers. And actually, I have to tell you, at the Leg meeting, it was a civil engineer within the membership who stood up and said, we must support this bill. This is unfair. I have to hire these people to tell me I don't know how to do some of this cleanup work that's done throughout the state. He said this is fair and we need to support this important legislation.
Thank you. Other witnesses in support? Any witnesses in opposition? Please come forward.
Thank you, Mr. Chair and members. Steve Baker with Aaron Reed & Associates, representing the professional engineers in California government. We were here before this committee last year and opposed the bill. We remain opposed. The amendments don't do anything to help remove our opposition. If anything, we think that the bill is going in the wrong direction with providing the overlap of all of the engineering disciplines. The reason for professional licensure in any category is to protect the public health and safety. We don't see how allowing overlap between all of the professions and allow those professions to self-certify their competence protects the public safety. And for those reasons, we remain opposed to the bill and would ask for a no vote.
Mr. Chair, members, Mark Smith on behalf of the American Council of Engineering Companies of California. For the reasons previously stated, we also oppose this bill. Thank you.
Happy New Year, Mr. Chairman, members. Richard Markison, representing the American Society of Civil Engineers. 17,000 or so civil engineers in public and private practice were also opposed. And unfortunately, I think that much of the testimony has suggested that the current Professional Engineers Act grants a monopoly to civil engineers. We would look at it from a slightly different perspective, and we think that the current PE Act protects the public from the unwarranted or unprepared engineer from practicing civil engineer, which this bill would now permit them to do. A number of the Title Act engineers who would be elevated to a Practice Act engineer and by the bill be allowed to practice civil engineering have actually never tested and demonstrated their competency to the Engineers Board. When the Title Acts were created, a number of practitioners were grandfathered into their title and never tested. That simply does not exist for civil, electrical, and mechanical engineers. This is unwarranted. We actually think that the public would be put at risk from this. We're opposed and urge you to vote no.
Thank you. Any other comments in opposition? Members, any comments?